Contesting a will is the legal process of challenging either the validity of the will or alternatively challenging the way in which the estate is administered, which doesn't affect the validity of the will and leaves that intact. There are a variety of people who can contest a will. In certain claims that's very specific and there are categories of people, but generally speaking, anyone who is either affected by the will, so disappointed beneficiaries, they can challenge the will. The grounds for contesting a will can generally be divided into 5 elements. Firstly, the form and execution of the will. The will must be executed in an appropriate form, which is set out in the Wills Act 1837. The second basis of challenge that's often used is testamentary capacity. The person executing the will must have the requisite testamentary capacity that's set down in law in order to execute a valid will. The third basis upon which wills are often challenged is knowledge and approval. The person making the will must know of and approve of the contents of the will in order for it to be valid. The fourth basis of challenge when dealing with validity of the wills is undue influence. So the testator's will must be their own. If those will and wishes are overpowered and they are not their own, then the will can be deemed invalid. And the fifth and final basis upon which wills can often be challenged are either fraud or forgery, which obviously is circumstances where the will is not their own and has been created fictitiously by another. Time limits for contesting a will are specific to the types of claim that you bring. Certain claims have time limits attached to them. So for example, if you claim for financial provision under the Inheritance Provision for Family and Dependents Act 1975, there is a strict time limit to that, which is 6 months from the date of the grant of probate, or if there's no will, 6 months from the date of the grant of letters of administration. For all other claims dealing with the validity of the will, there is no strict time limit, but delay should be avoided if possible. Delay can often lead to practical difficulties such as the estate already being administered. The rules of intestacy govern the position where someone dies without a will. They are effectively a set of rules which act as a flowchart that sequence the order of who gets what and when. So, for example, if someone dies without a will and they are married with 2 adult children and their estate were, for example, £600,000, the rules of intestacy would dictate that the surviving spouse, would receive all personal possessions and the first £322,000 of the estate. The balance of the estate would then be divided in half. Half would go to the children in equal shares and the other half would go to the spouse. The rules of intestacy then have some further complicated rules which deal with situations where people have predeceased the person. So for example, in that scenario, if the children had predeceased, then their children, the grandchildren of the deceased person, would receive their share. In short, the rules of intestacy offer a sequence of who gets what in what order in circumstances where there is no will.